So this is the first lecture actually of the roundtable. The lecture is entitled very ambitiously Populist Trends with a question mark, when the rule of law meets digital technology. So you will probably be able to make the link with the presentations that we heard before lunch. So that's interesting. But before we go there, I just wanted to share this slide with you that I very much like. This picture is taken, the top picture of our students is taken in the moot court room downstairs here on the ground floor at UCLan Cyprus. And you can see how determined young people they look like, and they are thriving in life. And I think this represents well what the EU POP project is trying to do. Between research-informed teaching, knowledge transfer, and strategic litigation in the field of the rule of law and populism. Why strategic litigation? Well, by trying to enrich the debate at the European international level through reporting and monitoring of issues arising out of populist phenomena, we are hoping to be able to participate, and I think we are proving to participate to raising awareness of human rights and the rule of law specifically. Now, in terms of digital populism, which could be the short title of that presentation, of that lecture, let me bring to you some of the findings of two projects. One is EU POP, as you know, and the other one is the Sherpa project that I actually mentioned before lunch when listening to Carlota. So Sherpa is a Horizon Europe, Horizon 2020 project that actually completed a few months ago, and that is very relevant to the work that we do on populism in EU POP. So let me try to tease out for you why it is relevant. It is relevant because we have been speaking quite a lot already about the various aspects of digital life. So what is digital life? Well, it is our lives nowadays that are filled with smart information systems, or SIS. By SIS, you need to basically have in mind big data, but also artificial intelligence and basically Internet of Things. Examples of such systems include, of course, Alexa, but also robots, as we have already discussed this morning, social network data analysis of various types, such as, for example, personal advertising and so on and so forth. What do they have all in common? What they have in common is that it's the use of mass data. Mass data can be found everywhere in blogs, websites, on the internet, profiles on social networking websites, digital libraries, Internet of Things, autonomous machines such as robots, vehicles in drones, and so on and so forth. So we are surrounded and we are penetrated by mass data. And of course, that comes with cost. The cost of privacy vis-a-vis those machine learning businesses and systems. So it is a lucrative business. The use of big data to assess markets, predict consumer behavior, identify trends, or train machine algorithms is a lucrative business or occupation. And of course, the worst part of it is that the technological developments of those technologies and systems is much faster than anything else, and particularly is much faster than the legal and ethical framework. If you are interested in learning more about the legal and ethical consequences of digital life, feel free to download that publication from the Sherpa project, which is mentioned here in the slide. So smart information systems are in our lives, and there are benefits to it. We can't really say that there are only disadvantages to it or threats or risks attached to it. And there are benefits at the individual, but also at the collective level. So if you think about the use of big data that can assist in real time to take decisions during crisis situations, for example. An example given in the literature is the one of the earthquake in Haiti in 2009, or during the Hurricane Sandy in New York later, whereby millions of tweets or millions of messages on social media could actually, or crowdsourced maps could actually mark people as safe, or actually attract attention for rescuing. This has been used and further developed in the pandemic in the context of COVID. And I'm raising here the question as to whether, it has any relevance to situations of civil unrest or civil disobedience. It probably has. It definitely has a role to play in real-time emergencies of the natural disaster type. Okay, very good. Okay, natural disaster type and also terrorist attacks. You know that lately, the past 10 years or so, people have been able to mark themselves as safe or in difficulties, and in times of war as well. Now, of course, smart information systems can support human rights fact-finding by providing a basis for estimating the probability that an individual belongs to a group that has been subjected to, for example, human rights violations. So an example is the capability of access to millions of mobile phone records in a large city that may reveal patterns of calls by individuals that suggest human trafficking for commercial sexual exploitation, for instance. But of course, all this technology in the hands of perhaps the wrong persons may rise or may lead to some abuses, possible abuses, and I think we can all think of possible abuses of the use of data stemming out of millions of mobile phone recordings. And there is, of course, the healthcare aspects of smart information systems. SIS, particularly robotics and artificial intelligence, have been extremely helpful in the delivery or the provision of public services in the field of health through, for example, smart hospitals or smart services, particularly during the pandemic, that has proved to be very helpful and has developed quite a lot. Wearable technologies are also very interesting aspects of things, whereby each of us can use, and measure our metrics, upload our data, check our health and everything. Now, all those aspects of digital life are, of course, problematic in the sense that they give rise to multiple ethical and philosophical, moral and legal questions. And in the Sherpa project, we decided to focus on, as you can see here, some of those aspects, not all. It's not possible to be exhaustive. But if you look at, for example, privacy and data protection, which is here on the slide in yellow, but also accountability and liability, bias and discrimination, democracy and freedom of thought and control and manipulation, or even the rights of robots, as we heard before, you can start thinking why this is of relevance to populist trends. All those areas are, of course, of high relevance to freedom of speech and freedom of thought and equal access without any manipulation of the data. So combating of misinformation. So how can the social legal challenges in the field of smart information systems as identified in the previous slide, reinforce or participate to populist trends. So they can both combat them, address them, or aggravate them. Well, here on the right-hand side of this slide, you've got a picture of snapshots of a social media campaign that EU Pop did back in January 2021. This is a picture from this is a picture from Washington, as you can see. And during that time at EU Pop, we were trying to find well, quotes or philosophical considerations that would help us to understand what was happening at that point. And that one, I think, by Montesquieu is probably one that we can reflect on here. The deterioration of the government begins with the decay of the principles in which it was founded. And you will see that in the end, digital populism is actually not far at all from those principles on which our democracies are founded. So what are the possible considerations of smart information systems that are of high relevance to populist trends? This quote, I think, is quite interesting by Boyd and Crawford that says big data is viewed as a troubling manifestation of Big Brother, a Big Brother regime where liberty and fundamental rights are threatened. How are these threatened? Dangers include privacy incursions, I think that's quite clear, but also invasive marketing, as we said before, even the tracking of protesters, or the suppression of free speech or speech. So basically, that social change occurs everywhere, as Richards and King would say, from dating to voting. So potentially all our civil liberties and our human rights are potentially affected by the use of mass data, including voting. And some behaviors or social behaviors that other experts in, for example, behavioral sciences would consider seem to be reinforced, such as the one of apophenia, which is the trend, see patterns of threats, whereas they do not necessarily exist, which is sometimes also referred to as conspiracy theories. How does this occur? Through the superficial observation of massive quantity of data without any ontology, without any ontological assumptions and methodology, and also combating of biases, which is sufficiently robust to come up with a supposed or alleged pattern. So all those trends are potentially relevant to populism. And last but not least, so for the widespread societal acceptance of smart information systems, social realities must be embedded or must penetrate the technology. So the question arises as to what are the social realities that we need to embed into the technology so that we can accept smart information systems as a technology or as, yes, as technologies. Well, that was already actually mentioned this morning by Carlota. The ethics by design of technologies is a good suggestion, a good way to make sure that there is a sufficient level of societal acceptance of smart information systems. What is ethics by design in technologies? It's basically the idea that every technology must be designed initially with ethics and moral and legal considerations in mind. So we do not test the system once it's ready. We build the system with those considerations inherent into the systems. So of course, when you look at the complexities, the technical complexities of smart technologies, you understand how difficult it can be to produce ethics by design. And this is why there is a role for strategy litigation and advocacy to make sure that at the level of decision makers, whether these are international, European, or national, the idea of having ethics by design in the regulation, in the governance, as was mentioned also by Carlota in the morning, is an important one. So it remains that this ethics by design must reflect the principles that are essential to a democratic society. And this is where what I said before, I said that basically smart information systems must rely on social realities that embrace the founding principles of our democracies. This is now confirmed. So it's one thing to say that, you know, ethics by designing technologies must be based on the principles essential to a democratic society, but it's another thing to actually be able to adjust or incorporate or measure or benchmark smart information systems in the digital world with rule of law principles or other democratic principles that we have been applying for centuries. So what is the role of the rule of law in the digital world? Well, of course, it depends on what you mean by the rule of law, and this is not, let's say, the subject of today's lecture, but there are various interpretations of the rule of law. There can be a thin interpretation of the rule of law, which is more procedural, or thicker interpretation of the rule of law, which is more substantial. So the rule of law can be treated as a procedural guarantee, but the rule of law can also be considered as a substantive concept, which has connections with various other values and principles, such as democracy and human rights. And it's the same in the digital world. That's not going to change. There are different approaches to the rule of law there too, but they are expressed slightly differently. What matters, though, is that the principles of the rule of law applicable in the digital world should remain the same: transparency, accountability, due process, fairness, etc. And if you look at the EU declarations of digital principles that was released back in December 21, if I'm not mistaken, perhaps even January 22, those principles are high on the agenda. So we find the same principles as we have been used to work with in terms of the rule of law of relevance to the digital world. And of course, all those existing frameworks at the European and international level that deal with the measuring, the monitoring of the state of the rule of law and values in specific jurisdictions, countries, regions of the world, are not fully equipped yet to deal with such indicators in the digital world, but this is something that we will need to improve and progress. So there is definitely a non-negligible impact of the digital world on the rule of law, and this needs to be addressed in the regulation, in the framework, in the governance of a modern democracy. So the rule of law in the digital world needs to be basically recognized as something that is very important. Well, actually, it already exists. I mean, it may not be called the rule of law in the digital world, but there are a lot of experts and academics, but also policymakers that are referring to principles and to rules that very much look like the rule of law. But they come from different disciplines and different backgrounds. Engineering, for example, is one. So since the characteristics of machine learning and narrow artificial intelligence are quite opposed to the rule of law, opacity, unpredictability, and all the requirements of big data. This is what we need to address. And the peculiarities of smart information systems is that neither the developer, nor the deployer, nor the user of the technology can normally know in advance how a system will react to a given set of data, situations, and inputs. So the system is created, but it needs to be tested and validated in order to be, let's say, commercialized. So in the digital world, past behaviors are not always good indicators. So they cannot always constitute precedents because the technology is different and the technology is already older, sometimes obsolete. And that's because, of course, of constant technological progress. So this is something that may be difficult to address in the rule of law framework in a traditional sense. But if you bear in mind that what needs to be framed is the characteristics of the smart information system, such as opacity, unpredictability, and the big data requirements, then it becomes easier to correlate some of the rule of law principles and values with those characteristics. Of course, questions of legal and ethical accountability and reliability of AI systems arise out of what we just said. So the main question is, who has the most oversight over the technology? Who has control over the risks? And where does that leave the user? And of course, all those questions must be normally addressed by the legal framework in place, obviously. So we have elements of answers through the GDPR, which actually gives us quite a range of tools and rights to be able to apprehend the technology. But there are other phenomena, digital phenomena, that are not necessarily directly embedded into the GDPR, particularly cybersecurity and the proper use of data. Proper use of data. That is a very important word. Because what we may end up having with an abusive use of a massive amount of data is a data crisis. So what is a data crisis? For me, it's a situation that combines a lack of reliability of the data with its opacity and its unpredictability, together with a massive security breach. We have plenty of examples of massive security breaches of data arising from manipulation of voters to cyber attacks, just to mention these two. So the most important question, that is a rule of law question, is actually how to ensure the integrity of the data. And the word integrity by itself is a word that we are used to in the field of rule of law and values and European values. So in my view, that's not too far away from the usual rule of law considerations, actually. Whether we call it, an ecosystem because it's interdisciplinary, or whether we call it the rule of law, framework, I don't think that there is actually a very big difference. Even technologies have wider social technical frameworks and backgrounds, as Stahl wrote in his book. Stahl is someone with whom we worked. He's the coordinator of Sherpa, actually. So autonomy is a social technical characteristic of smart information system. Autonomy. Most technologies function away from human beings. Another possible characteristic which must be framed is manipulation. the structuring of human options and possible course of actions in ways that humans do not realize. And of course, the third aspect that needs to be framed in these rule of law considerations is the social impacts of living in a digital world. So again, in my view, all those characteristics are actually addressed in the usual European public legal order, which is composed of, the ECHR and the EU Charter and the case law of the Strasbourg and the Luxembourg Court. So, in fact, all we need to consider is whether we need to have specific digital principles in this European public legal order. And some of the characteristics of this digital addition to the European public legal order could be the ones that would address the most obvious form of human rights interferences by technologies. Profiling, prediction of behaviors, influence of opinions or choices, predicting, policing, mass tracking, surveillance, and micro-targeting, biases and discrimination, or distorted access to information, which is very important. Sometimes we call it as the net neutrality principle, but also access to competition, which we also call the walled gardens of dominant players in the world of technology. So the risks to human rights include direct or indirect violations of individual rights, erosion of democratic rights and rule of law principles and values, the loss of the quality of data, the polarization of opinions and beliefs, which is highly relevant to what we're discussing today, or the loss of a pluralistic media ecosystem and freedom of information and expression. This comes from the CAHI group of the Council of Europe, which has now changed mandate and has become the CAI. It's the Council of Europe group that deals with artificial intelligence. So it seems that there are plenty of instruments that are navigating around the traditional legal instruments on the protection of human rights in the European legal order. And actually, the traditional instruments, legal instruments of protection of human rights, already address many of the situations that are aggravated or exacerbated by technologies, such as around biases, but also around discriminations, possible profiling, and the right to privacy. So all those obviously are already protected by existing legal instruments, such as the CHR or the EU Charter. But is there a risk of backsliding of the rule of law in digital times or in the digital world? Well, there is probably a risk, the way there is a backsliding of the rule of law, generally speaking, in our modern societies. But the risk is existing and is actually quite enhanced in the digital world. So that perhaps could be a good reason to think about a centralized approach to the rule of law in digital times or the digital world. Let me just see if it's someone who wants to join us. No? Okay. It seems to be another meeting. Yes, it's on my other screen there. So if we agree that the backsliding of fighting against the backsliding of the rule of law in the digital world is actually as important as or maybe even more important as than simply fighting the backsliding of the rule of law in the physical world, let's say, then I think we can look at the principles that have been suggested by multiple organizations or international organizations and experts groups that have probably all worked around very common principles for us, very known principles for us, such as the ones that are here on the slides that are taken from the EU's high-level expert group on artificial intelligence that are working on the framework for a trustworthy artificial intelligence, or AI. Trustworthy AI is basically lawful, ethical, and robust AI. And those principles, as I said, they are not new. They are basically safeguards against the fact that there is too much autonomy of technologies. So there needs to be a principle of human agency and oversight principle of the technology. There needs to be technical robustness and safety principle. There needs to be, of course, privacy and data governance principle. There needs to be transparency as a principle, diversity, non-discrimination, and fairness as a principle, social and environmental well-being as a principle, and accountability as a principle. So we are actually using the same principles and values as in the traditional European public legal order, I would say. And those can easily be benchmarked against the conceptual interpretations of the rule of law principles. And that would be quite interesting research paper if anyone is interested in that. Additionally, however, or let's say as a manifestation of those principles, the European digital public legal order is currently in the making. And this digital addition to the European public legal order is composed of multiple instruments, many of which are still drafts, they are still proposals. Others are softer than harder laws, but nevertheless, we have a very interesting collection of legal texts at the moment, which have culminated in 2021-22 in the creation, the establishment of important legal texts. One of which is the EU Digital Principles Declaration that I mentioned before, the Digital Services Act, which is still pending, and the draft regulation for European approach for artificial intelligence, which is still pending too, and is very much discussed. So that shows, at least at the European level, whether it's the EU or Council of Europe level, a clear intention to frame some technology or even to frame all technologies, but in different ways, depending on the level of interference of a specific technology with human rights. That is the basic approach of those instruments. But it's not always easy because many of those instruments are based on existing powers of international organizations. So if you take the European Union, for example, and if you look at the draft regulation for European approach to artificial intelligence, to AI, the raison d'être, the legal basis for that act is actually the single market. So it is the need for data to flow freely. It is the need for the free movement provisions to continue applying in the digital world that drives the proposal. So obviously that means that even though human rights are very prominently expressed in the draft, the approach is not a human rights-based approach. It's a single market-based approach. So that is, I think, where is the challenge? The challenge for us now remains to transit from a European digital legal order to a European digital public legal order, whereby human rights are fully integrated into the approach and fully protected in the digital world. Otherwise, we risk having again, phenomena of rule of law backsliding in the digital world, this time appearing as a very concrete reality. So my main recommendation in this aspect, in this field, would be to work on a sort of a rule of law due diligence. So the way we have, due diligence exercises carried out in so many different fields of commercial, corporate law, financial transactions, and the likes. So in the field of compliance, in other words, we could think of a rule of law due diligence requirements that would bind all stakeholders. So not only the producers of technologies, not only the operators, not only the data controllers, but actually all the stakeholders into rule of law due diligence. So it's a bit different from rule of law conditionality, whereby conditionality of the rule of law means that certain rights are made subject to compliance with the rule of law. The rule of law due diligence is rather more of an impact assessment exercise, not a risk assessment, an impact assessment exercise, whereby questions need to happen and be answered at the very beginning. So it is built on this idea of ethics by design, but it has a focus on the rule of law and a due diligence process, recognizing that not only the designers of the technology need to be included. So in the next very few slides I have left, I just wanted to share with you some of the recommendations that Konstantinos, Alexandra, and I wrote in the multiple public consultations of the European Commission in the past few months, of relevance to everything we do here, so of relevance to EU POP, but also relevance to Sherpa and to, generally speaking, rule of law exercises that we do under the Center of Excellence that we have now created at the school, CROLEF, the Center for the Rule of Law and European Values. That specific public consultation was on the EU digital principles that I mentioned before. So before the EU Declaration of Digital Principles in Context was published, we actually participated in the public consultation. And one of the recommendations that I wanted to share with you in a nutshell was around the sustainability of digital rights at the EU level. So having done a lot of work on the sustainability of rights, generally speaking, in times of crisis, particularly sustainability of socioeconomic rights, I can only think that it's very important to transpose that idea of sustainability of rights to the digital world and insist on the fact that it's especially in times of crisis, especially in difficult times, in troubled times, that rights must be sustained. And this is, of course, very true about digital rights or rights in the digital world or rights in their digital format. All of those must be at the center of the EU action. And in my view, this is best, or in our view, this is best addressed at the centralized level of the European Union, not only at the national level. It needs to be centralized and a collective action. And of course, many of the recommendations we made in Sherpa as a consortium are relevant here to allow for this sustainability of rights in digital times or digital rights in times of crisis, because this cannot be done at the EU level until and unless there are at least there are some principles that are there too. One of them is to have an independent EU agency that would actually deal with artificial intelligence. Having an AI officer in all those organizations that are involved in the digital technology and the digital world, including business organizations. And as I said before, having a sort of rule of law due diligence mechanism to penetrate and to enhance the rule of law culture in the field of technology and in the digital world. So those are some of the recommendations. Of course, they come over and above everything that must be said about education of citizens on technologies and on the role of ethics and other considerations in the field of smart information system. And then the last point I wanted to raise with you is derives from another public consultation Konstantinos and I engaged with. This time on the draft regulation on the regulation of artificial intelligence presented by the European Commission. And I wanted to share with you basically not so much the contents of the draft regulation, which is a risk-based approach. So it's not, as I said before, a human rights-based approach. It's a risk-based approach with a categorization of risks to human rights. So there are low-risk technologies that are not regulated. There are medium-risk technologies, and then there are, or medium to high, and then there are unacceptable risks. And most of the requirements apply to high risks, let's say, technologies, leaving out of the scope of the regulation all the minimal risk technologies, which are, however, potentially very damaging to human rights. But if we are to approach or to adopt such an approach, which seems to be the case because the draft proposal is actually very advanced in the process, then what we would insist on is the introduction of new rights. And those new rights are directly relevant to the populist trends that we have identified and we keep talking about in EU Pop. And here you have a list of some of the new, or let's say not so new, but let's say some of the digitalized rights we think should make their way into the case law of courts and hopefully into the regulation of international organizations and other bodies. In addition to traditional legal instruments, we have identified the right not to be manipulated and the right to be neutrally informed online as being two of the most important rights that we think are missing expressly, let's say. I mean, they can be protected as we are now via more traditional and general rights, but not necessarily. Yes, there is someone waiting in the lobby. Okay, good. But I think those rights deserve to be singled out or expressed more clearly, more certainly, as rights on their own and enshrined in relevant instruments and in case law. So these are the two that have most importance to populist trends, as constituting an additional safeguard to ensure that artificial intelligence in questions and other technologies in questions adheres to the principles of freedom of information. And then we have identified one more right, which is the right to a meaningful human contact to fight and possibly tackle some of the risks associated to those automated systems that are characterized by opacity, unpredictability, and risk-based to socio-economic rights, let's say. So the right to meaningful human contact, that goes very much beyond what is contained in the regulation, in the draft regulation, in the form of transparency or of human oversight. If you remember, we said that human oversight of the technology is one of the principles that is recommended by those rule of law groups that have been working on artificial intelligence. But the right to meaningful human contact will go beyond that. So obviously the EU Charter is there, and as I said, those rights are protected, generally speaking. But is the EU Charter fully equipped in the digital age? It is in terms of privacy and rights to family life and rights to data protection. It may not be in terms of artificial intelligence. So this is what I wanted to share with you. I thank you very much. I think we have a bit of time for questions. So if you don't mind, I'm going to unshare my screen. It'll be easier. I'm going to check the chat as well, see whether this is the... I don't think there is anything in the chat. Ah, and there is also Dinesh. Okay, Carlotta?
Thank you. I'll switch my camera on. Okay. Thank you for the presentation.
You're muted.
I actually have two
You're
quick questions.
muted. Or I can't hear you.
I'm not.
Can you hear her?
Can you hear me?
Can you try again?
Wait, I can.
Can hear you now.
Can you hear me? Okay. Otherwise, I just switch to. So thank you for your presentation. I actually have two quick questions. The first one is about the concept of due diligence that you mentioned. And if I'm not wrong, it's similar to also the participatory approach to the lawmaking process, the developing of technology that I think it's also quite used in academia. And I was wondering whether you also examine how to implement in practice this due diligence principle, because not I'm usually talking about like participatory approach, and I think it's extremely interesting and useful. But sometimes I wonder whether it works in practice, because also when we try to apply when doing qualitative research, it's already complicated to have like multi-stakeholders. So that's the first question. And the second question is about what do you mean with like meaningful human I don't remember what you contact, because when I was listening at you, I thought, oh, this really reminds me of the prohibition on automated decision making. So the fact that you also you always need like human supervision. So I was wondering to what extent you think that this supervision / oversight is different from the meaningful. Thanks.
Thank you, Carlotta. I think we'll answer those and then we'll go to Dinesh or whoever asks questions. So about the practical implication of the rule of your due diligence. Yes, of course, it may be. So one of the dimensions, the one you identified, which is the participatory dimension, to make sure that there is coordination amongst all the stakeholders. That is one challenge, and you're right about that. One example I have been looking at is the human rights in business approach of the UN. As an example of a due diligence approach that actually binds multiple stakeholders. And I find that very interesting. So in the forms of guidelines, with some more or less softer or harder instruments, it is possible to unify or let's say to bring everyone around this idea of your due diligence process. It's for human rights in businesses, but I think we could do something similar for stakeholders in the field of technologies, in my view. Now, this rule of your due diligence recommendation cannot come on its own. There needs to be other recommendations in force, particularly having an AI officer or an ethics officer in businesses, but also in other stakeholders would be a way to perhaps make sure that those guidelines at the international or the European level are actually complied with or followed in at stakeholders' premises and in among entities. So I think these are the two areas where I would think there is room for further research And it's, I think, very interesting. Now, the other point, which was around the last slide. So the last slide spoke about, just a second, I'm going back to, it talks about specifically the right to meaningful human contact, going beyond the obligation of transparency in the regulation. That is the idea that, yes, the principle of human oversight is there, but the issue is the human oversight of the technology is usually understood at the level of the design of the technology and not necessarily the use of the technology. So this idea of a meaningful contact, human contact, is probably to be seen from the side of the user as opposed to be seen from the side of the holder or the producer of the exploiter of the technology. So I think this is food for thought. And perhaps we can talk a bit more about those rights, which I think are worth looking into, including from the perspective you suggested this morning.
Definitely, thank you very much.
You're welcome, Carlotta. There is a comment from Dinesh. Dinesh, do you want to come in or should I read? So I will read. Does the new draft digital rules will they incorporate or acknowledge the international human rights norms, such as provided in the ICCPR, likewise freedom of speech and expression? And if it is practiced in full scale, it will not raise issues such as defamation, particularly of minority groups, which generally populist government fails to protect or even undermines. Examples of such acts can be easily visible in cases from Europe as well as countries like India. Yes, with right-wing Hindu populism. Okay, Dinesh, yes, of course, you're right. Thank you. I don't know if you want to tell us a bit more about right-wing Hindu populism, because for us, that would be very interesting. For all of us. I don't know if you have a mic.
Hello.
Yes, we
Hello.
can hear you.
Can
Not
you hear
very
me?
strongly, but we can hear you.
Yeah. Hello. Hi, everyone. Thank you for giving me an opportunity for participating in this conference. Uh, so I have gone through the lecture. So it was quite interesting because artificial intelligence is in a quite important field all over the world because of the growing importance of the technology, and the interference of law in technology is quite relevant because we see the use of artificial intelligence in all over the world with the various platforms and social medias is increasing day by day. And in the COVID pandemic era, we have faced this situation wherein we have used the technology at large scale for connecting through people in various fields like academics especially. So my question is particularly that the European Union have a, do they have a consideration for freedom of speech is in respect to the violations while uh, having some giving a right of freedom of speech in full scale, which can go against the minorities, which is quite visible in many places like in Twitter or Facebook and other platforms, when people have a freedom of speech and expression and they used to comment anything which violates certain rights of other people, gives the provision for defamation and discrimination against, especially to women and gender, which is very common in platforms such like that women are facing such issues. And the provisions, the companies like big corporates like Facebook and Twitter, they are not handling it properly. Even they have a recourse, like in India, Indian government has recently faced in a, they have framed in a some rules. So Twitter and Facebook have to appoint some enforcement officers to take care of such issues, like if such kind of discrimination comes. But it is not much effective, as in my case, I have observed this thing. I once there was an incident, I found some kind of post on Facebook which was quite discriminating against the community standards of Indian law. and it was going against women's and gender. It was like quite a gender discrimination and a kind of a sexual activity, which when I complained it to the Facebook Indian office, they took cognizance of that, but at the end, their report was like that it doesn't match the against the community standards of Facebook. So I was quite surprised. It was surprising to me that how can it be? So like Facebook standards are not up to the provisions for protecting the rights of communities, especially the minorities, gender, and all those. So I just want to ask that is it same with the European part? Are they
Yes.
also facing the same situations?
Yeah.
And if they are facing the same situations, the European Union and the other bodies and the law enforcement agencies, are they taking care of to frame out some laws which can protect these and safeguard the interest of the people in this respect?
Thank you, Dinesh. Um, there are efforts across the European Union at the EU level mainly, but also across Europe through the Council of Europe to frame platforms and intermediaries in particular, uh, as long as they have some sort of presence in Europe or in the European Union, and to comply with the legal instruments, including the ones that are forthcoming. So that's for sure. And an interesting example of this is the GDPR, whereby, so GDPR already is in force, and whereby clearly not only is there an expectation that any controller of data, no matter where they come from, who operates on the EU ground is subject to the GDPR, but it's more than that, because there is this principle of, let's say, extraterritoriality of the GDPR, because the transfer of personal data to outside of the European Union is also regulated by the GDPR. So this is probably a very interesting legal mechanism to repeat in other instruments, but it only works if you have something to control, like data. So it may not always be relevant for what you are discussing, but it's part of the answer. Now, generally speaking, if you look at the draft regulation on the regulation of AI, it's a huge document, but what is most striking is the recitals. The recitals are about half of the document, and the recitals are very specific as to international and European norms of protection and safeguarding of human rights. So you find multiple references to many different principles and international instruments. And generally speaking, international human rights norms are highly regarded in the EU legal order. They are reflected in the EU treaty, and they're also reflected in this draft regulation. So there is a lot of work to be done, particularly because what you referred to may not necessarily entail AI. It may simply be a question of platforms and intermediaries, which is subject to a different legal text, let's say. But even if it does entail some AI profiling, for example, it may not be considered in this category of, high risk AI that would fall under the scope of the draft regulation. So in a sense, we are back to the discussion that we're having, how we can ensure that even AI and other technologies considered to be of lower risk to human rights can be framed in this framework. And there are, of course, instruments in the form of codes of conduct. So basically, the European Commission is recommended in the draft regulation that not only high-risk AI is regulated, but also lower-risk AI is addressed through a code of conduct. So softer instruments. And it makes a very interesting read, even for colleagues in India and in other places where obviously, the regulation would not apply directly. But because of the international nature of digital platforms and of technologies, it makes sense to look at the EU example. As I said, it's still pending. Anyone else had any questions? It's actually, we're right on time for the break, but
Thank you.
thank you, Dinesh. If no one else has anything to ask. I don't know can you hear Nadia? People online? No, so I think I switch.
Okay, I hope now it's clear. My question is very relevant to what Dinesh put on the table, because he put down the international perspective with his own Southeast Asian perspective. I was wondering, in suggesting these new rights, whether your research has actually taken into account criticisms to the way human rights work, because we are in a situation where more and more, unfortunately, we have more negative stories about human rights, and there is a lot of research on how we should actually take it maybe a step back and reevaluate the whole concept of human rights. So for me, if we only suggest new rights without contextualizing it in all the problems human rights as a concept from a legal, from a philosophical, from a sociological perspective have, for me, it always feels a bit out of place. So I was wondering if this was taken into account in the research.
Thank you, Nadia. This is very interesting. And maybe suggested a new human right is somehow ambitious and perhaps even arrogant, whereas suggesting the digital version of a right is what I was suggesting. Yeah, so I think you're right about the negative narrative and discourse around creating new human rights. I kind of agree, and I felt it in Brussels, actually. Depending on who is talking, you can feel, the narrative, the approach. But I think it's about recognizing that legal instruments as they are probably good enough to protect human rights, but they do not consider the more modern dimension of rights. Yes, so it's perhaps modernizing a little bit primary rights and recognizing that they have a digital existence, which is perhaps not fully addressed as we are. And we know that this is the case because we're now going through multiple lawmaking processes to address specifically the digital version of those rights. So I think maybe that would be the approach.
That nuance adds a lot to the discussion.
Yeah, it does.
I think we already have seen the very basic aspect of that by with the UN declaring access to Wi-Fi, for example, being one of the rights that exists. So yeah, it's ambitious. I wouldn't say arrogant, but ambitious for sure.
Happy to work on this with you, Nadia. At some point. Okay, so Dinesh, I think we will take your question later because we need to have a short break before we listen to Alex, who I think has joined us already from what I can see here. Can I propose that we take a 15 minutes comfort break, if that's okay with everyone? I will not close the meeting, so please stay on the meeting. I will just stop the recording and start it again when we reconvene at 35 past for Alex's presentation. Thank you, everyone, for keeping with us, and I hope you're enjoying it.